This is English shorthand dictation number 322 and the dictation speed is 120 words per minute. Ready? Start. Aggrieved by the original order dated August 22, 2011, the SSE preferred an appeal before Commissioner Appeals. The Commissioner Appeals wide order dated March 15, 2012 allowed the appeal and set aside the original order holding that SSE is eligible for availment of service tax paid on goods transport agency service on the outward freight from the factory to the customer's premises as per the board's circular dated August 23, 2007. It was now the turn of the revenue to feel aggrieved by the order. Accordingly, appeal was filed before the Customs, Excise and Service Tax Appellate Tribunal by the Revenue, which was rejected wide judgment dated 1st of May 2015. Further appeal to the High Court preferred by the SSE has met the same fate as the said appeal has been dismissed by the High Court of Karnataka wide its judgment dated June 29, 2016, which is the subject matter of the present appeal. As mentioned above, the SSE is involved in packing and clearing of cement. It is supposed to pay the service tax on the aforesaid services. At the same time, it is entitled to avail the benefit of SENVAT credit in respect of any input service tax paid. In the instant case, input service tax was also paid on the outward transportation of the goods from factory to the customer's premises, of which the SSE claimed the credit. The question is as to whether it can be treated as input service. Input service is defined in Rule 2 of the Rules 2004. As per definition, input service means any service used by a provider of taxable service for providing an output services or used by the manufacturer whether directly or indirectly in or in relation to the manufacture of final products and clearance of final products up to the place of removal and includes services used in relation to setting up, modernization, renovation, or repairs of a factory premises of provider of output service or an office relating to such factory or premises, advertisement or sales promotion, market research, storage up to the place of removal, procurement of inputs, activities relating to business such as accounting, auditing, financing, recruitment and quality control, coaching and training, computer networking, credit rating, share registry, and security, inward transportation of inputs or capital goods, and outward transportation up to the place of removal. It is an admitted position that the instant case does not fall in subclause 1 and the issue is to be decided on the application of subclause 2. Reading of the aforesaid provision makes it clear that those services are included which are used by the manufacturer, whether directly or indirectly, in or in relation to the manufacture of final products and clearance of final products up to the place of removal. It may be relevant to point out here that the original definition of input service contained in Rule 2 of the Rules 2004 used the expression from the place of removal. As per the said definition, service used by the manufacturer of clearance of final products from the place of removal to the warehouse or customer's place, etc., was exigible for Senvat credit. This stands finally decided in Civil Appeal number 11710 of 2016, wide judgment dated January 17, 2018. However, wide judge amendment carried out in the aforesaid rules in the year 2008, which became effective from March 1, 2008. The word from is replaced by the word up to. Thus, it is only up to the place of removal that service is treated as input service. This amendment has changed the entire scenario. The benefit which was admissible even beyond the place of removal now gets terminated at the place of removal, and doors to the SENVAT credit of input tax paid gets closed at that place. This credit cannot travel from there. It becomes clear from the bare reading of this amended rule, which applies to the period in question, that the goods transport agency service used for the purpose of outward transportation of goods is not covered within the ambit of Rule 2 of Rules 2004. The word from is the indicator of starting point, whereas the expression up to signifies the terminating point, putting an end to the transport journey. The adjudicating authority was right in interpreting the input service as any service used by the manufacturer, whether directly or indirectly, and also includes inter alia services used in relation to inward transportation of inputs or export goods, and outward transportation up to the place of removal. The two clauses in the definition of input services take care to circumscribe input credit by stating that service used in relation to the clearance from the place of removal and service used for outward transportation up to the place of removal are to be treated as input service. The first clause does not mention transport service in particular. The second clause restricts transport service credit up to the place of removal. When these two clauses are read together, it becomes clear that transport services credit cannot go beyond transport up to the place of removal. The two clauses, the one dealing with general provision and other dealing with a specific item, are not to be read in disjunction so as to bring about conflict to defeat the law's scheme. The purpose of interpretation is to find harmony and reconciliation among the various provisions. Credit availability is in regard to inputs. The credit covers duty paid on input materials as well as tax paid on services used in or in relation to the manufacture of the final product. The final products are manufactured by the SSE in their factory premises, and once the final products are fully manufactured and cleared from the factory premises, the question of utilization of services does not arise, as such services cannot be considered as used in relation to the manufacture of the final product. Therefore, extending the credit beyond the point of removal of the final product on payment of duty would be contrary to the scheme of SENVAT credit rules.